the second is why the Equal Protection Clause be interpreted to require something resembling proportional representation?
Because it's entirely ahistorical, and keep in mind, the framers gave state legislatures the choice of ensuring proportional representation by having statewide elections, but they also gave them the choice to districts, which is fundamentally inconsistent with that. Thank you.
Thank you, counsel. Mr. Bondurant?
Mr. Chief Justice, may it please the court. This case involves the most extreme partisan gerrymander to rig congressional elections that has been presented to this court since the one-person, one-vote cases. The North Carolina legislature's defense is equally extreme. They take the position that no matter how predominant the intent, no matter how extreme the effects, there are absolutely no constitutional limitations.
When you use the word extreme, that implies a baseline. Extreme compared to what?
In this case, it is extreme in comparison to any statistical application of neutral redistricting principles in the context of the political geography of North Carolina. It was statistically impossible to come up with an 11-2 plan. Is this what the authors said? We're proposing a 10-3 partisan gerrymander because it's not possible to do an 11-2 plan. The statistics bear that out. Moreover, Dr. Chen's maps, which took every possible criteria that they used that was legitimate, applied them to 1,000 randomly drawn maps, showed multiple things. First, that you cannot possibly explain the 10-3 advantage based on political geography, democratic clustering, the application of independent redistricting principles, or pure chance. This is not the result of chance. You can only achieve it by making partisan advantage the predominant motivation.
Mr. Clement. Predominant. I understood your brief, and your friend on the other side characterized your brief as saying that any element of partisanship was bad. Is that your position?
No, Your Honor. Our position is that partisanship has to be at least a material factor, as it is in Arlington Heights or Mount Healthy. But in this case, we prove that was a predominant factor, and that is the ruling of the lower court.
Well, I guess it just rephrases the question of what constitutes a material factor.
Well, the difference between material and being immaterial, having no consequence, is a very real difference.
So just so I understand, any partisanship that has a consequence is impermissible under your view?
We do not need to go that far in this case because you have evidence of predominance. That is, this objective, partisan advantage, superseded every other conceivable objective.
I understand the view that it's the reality that it's an extreme case, but to state a principle that we're going to be able to apply to other cases, your definition of material is that it has a partisan consequence?
It is a material part of the decision, as in, for example, firing in Mount Healthy. If that was a material part of the decision of the school board to fire the school teacher, then he had made a prima facie case, which could then be defended based on either there were intervening causes, that is the real reason why you didn't show up to teach, or you have legitimate state interests that are being served. In this case, the North Carolina legislature below, did not advocate, contend in any way that there is any legitimate state interest of any kind served by partisan gerrymandering. So you have, under any of your analyses, Anderson verdict, a clear burden. You have clear vote dilution, intentional vote dilution, carefully thought out, skillfully executed.
Can I take you back to questions that were asked before? If you make a list of the so-called neutral criteria, compactness, contiguity, protecting incumbents, if that's really neutral, respecting certain natural features of the geography, and you have a computer program that includes all of those and weights them all, and let's assume all that is neutral. And at the end, what you get is a large number of maps that satisfy all those criteria. And I think that's realistic. That's what you will get. Then, and the legislature chooses from among those maps. How do you determine whether that choice is unconstitutional?
The choice would be the standards that the court has traditionally applied. Picking an example, the Island Trees school case, in which the court said that a Democratic school board could not use its discretionary choices to discriminate based on viewpoint by excluding Republican authors and Republican
No,
books.
but can you just answer that question? Because it's a real puzzle to me. So you've got, let's say you've got 100 maps, or you might even have 25. I think you probably had thousands. So you have all of these maps, and you have to choose among them. The legislature chooses among them. And you've already programmed in all of the so-called neutral criteria. How does the legislature go about choosing among those maps? Would anything other than just random choice be satisfactory?
The legislature has wide discretion as long as it does not attempt to do two things: dictate electoral outcomes, favor or disfavor a class of candidates. That is an easily administered.
That first one, dictate electoral outcomes, I think is going to turn on numbers, right? How much deviation from proportional representation is enough to dictate an outcome. So aren't we just back in the business of deciding what degree of tolerance we're willing to put up with from proportional representation? And we might pluck a number out of the air or see that, maybe 2/3 is used for veto override. So we like that. Where are we going to get the number at the business end of this?
The business end of it is looking how this is done. This was done by looking at voting history as the best predictor of voting behavior, sorting voters among districts to achieve a particular outcome, to guarantee that in 10 districts there would be safe Republican majorities in which the general election is essentially irrelevant and the primary election is the
Let me try one more time. So we've got, let's say that you have a range of outcomes with all of these neutral maps that satisfy the neutral criteria, and they extend from 10-2 in favor of Republicans to 10-2 in favor of Democrats. So which one do you choose? Do you have to choose? 9-3 for Republicans, 8-4, 6-6.
Clearly, it's an evidentiary matter in terms of intent. If the predominant intent is to favor one party, to penalize another based on their voting history, that goes too far. But
isn't that always going to be the case when you deviate too far from 6-6 in Justice Alito's hypothetical?
It certainly is going to be a question of factual proof. The closer you come to proportional representation, the harder it's going to be for a plaintiff to prove.
Well, there we go. I think that's the answer to the question, right? Is that you would like us to mandate proportional representation?
Not at all. Our position is you cannot discriminate intentionally against political parties and voters based on their political.
And the further
views
you
and their
deviate
voting
from
history.
proportional representation, the more likely you are to be found guilty of that.
It is purely an evidentiary question. This court itself said in Reynolds, it said again in Lulac, that in a case in which you look statewide and see proportional representation, it is less likely
So
that you have
each
partisan
case,
gerrymandering.
we're going to have to, as part of our mandatory jurisdiction, in every single redistricting case, look at the evidence to see why there was a deviation from the norm of proportional representation. That's the ask.
You're going to have to look at the case and determine whether or not the plaintiffs proved intentional, predominant partisan intent to discriminate based on.
I would think that would always be present as so long as you're deviating from proportional representation. What good reason could there be but partisanship?
Not at all. If the legislature in North Carolina could have picked any among hundreds of maps that would have produced either a 7-6, a 6-7, maybe an 8-5 representation. But here, that is not this case.
What do we do as well about the fact that about 20 states, as I understand it from your friend on the other side, have dealt with this problem through citizen initiatives as a remedy to deal with this, including, I think, 5 of them just this last election and a bunch more on the ballot in the coming election. Why should we wade into this when that alternative exists?
The simple answer, Justice Gorsuch, is this. The vast majority of states east of the Mississippi, including specifically North Carolina, do not have citizen initiative.
Can you amend your constitutions? That has happened in a lot of states too.
You can only amend the Constitution with the approval of the legislature in proposing an amendment that gets to the ballot and is then ratified. And that is not an effective remedy. And the states in which you have independent redistricting commissions are states in which those commissions were adopted over the dead bodies of the legislators by citizen initiative, passed overwhelmingly by the citizens in the face of legislative opposition.
Mr. Bondurant, what do you do with the fact that partisan identification is not the only basis on which people vote? You see electoral results change dramatically depending, for example, on the particular appeal of individual candidates, turning on who's at the head of the ticket rather than down ticket. And how do you deal with that? Those factors that depart from the arguments about the inevitability of electoral results based on partisan identification.
Your Honor, the social science and the experts in this field, which included Dr. Hoffler, who designed this plan, was the Republican Party's leading redistricting expert. He testified that based on social science and his 20 years of experience in redistricting in North Carolina, he could demonstrate that how a small, what are called voter tabulation districts had voted in past elections, whether Democratic or Republican, was the best predictor of how they would vote in future elections, and that all partisan gerrymandering in the modern era is based on that kind of social science.
Well, but the one thing that I forget which brief it is, but it turns out that a lot of the predictions in this area, and I don't know if this applies to North Carolina or not, proved to be very, very wrong very often. I mean, you have the famous example in the Veith case where the argument was this change would, or the method under challenge would never allow the election of Republican judges. And 15 days after the opinion came down, all the judges were Republican. I mean, and even as in the more recent cycle, I understand a lot of things that were never supposed to happen happened.
In this case, on this undisputed record, the way this was done was that Dr. Hoffler used a composite of 7 statewide elections over 4 election cycles to come up with a calculation of partisan advantage and predictability. And it predicted 10 Republican districts, and the Republicans won all 10. It predicted 3 Democratic districts. The Democrats won all 10. In 2018, they did the same thing. He used the same methodology in 2011 to design the districts that were in 2012.
Counsel, the reality is that with all statistical models, and we spend our lives based on them, insurance is paid on statistical models, health insurance premiums are based on statistical models. I'm given to understand by the amicus briefs in this case that nuclear plants are built based on statistical models. The one thing about statistical models is there's always the possibility of an aberration, correct?
There is a remote possibility sometimes.
And the sometimes happen. That's why they're a probability, right? A possibility.
Correct.
So the fact that you have one exception doesn't disprove the rule.
Certainly not 100 maps out of 24,000 maps.
Yes, but the problem I think your side throughout this morning has to deal with, a problem, is from this side of the bench to some people looking at the prior cases, there is a great concern that unless you have a very clear standard, you will turn many, many elections in the United States over to the judges. There's always someone who wants to contest it. They will always find experts of all kinds. And what you'll discover is judges simply deciding too much. Now, I've written about why I don't take that position, etc. But I'm not speaking for myself here. I'm speaking as a reader and an understander of what's on the other side. At least one thing. And I think it's important for you and the others to deal square on with that question.
And our square on answer to that question is, in this case, we prove beyond a reasonable doubt a predominant partisan intent that was admitted on this record and demonstrated statistically beyond any possibility of dispute. And we have proved an extreme partisan effect, not only on a statewide level, but on a district-specific level. In Dr. Mattingly's chart, 6 of the districts are extreme statistical outliers that would not be achieved in even one, in some instances, of 24,000 plans. That is this case. Moreover, this court has held that the Elections Clause is, number one, intended to provide limits on partisan gerrymandering. Justice Scalia said that in Veith. And this court has said the Elections Clause was a limited delegation of power to adopt procedural rules for time, place, and manner, but was not to provide power to dictate electoral outcomes or favor or disfavor a class of candidates. That is an understandable standard that legislators throughout this country can understand. They already are told that you can't discriminate based on political viewpoint. They're already told in redistricting you can't discriminate predominantly based on race.
Suppose the legislature had said, we have all these maps we can choose from, but we don't want to be too greedy, so we're going to pick a map solely for the purpose of giving us an advantage. We're going to pick a map that builds in a 7-5 advantage for us. Would there be a problem with that?
It would be very difficult to prove predominant partisan intent.
What if they said it outright? The only reason why we're picking this map is we want to build in a 7-5 advantage.
If, to take your hypothetical example, if in North Carolina the legislature said, we in our wisdom have decided that the people in Charlotte are going to be represented by a Democrat, the people in Asheville are going to be represented by a Republican, that we're going to split Guilford County and North Carolina A&T to ensure that the students in that school are going to be represented by a Republican in one district and a Republican in another. They would be dictating electoral outcomes even if it were 7-6. The whole idea of the democratic process in a general election is the people elect a member of Congress in a general election which everybody can vote. And when you rig the districts in that manner, you are making the general election irrelevant. You're making the primary election in which only some people can vote.
So even if the map provides only a very small partisan advantage, that would be subject to challenge in litigation.
If, in the facts that I posited, you had the legislature essentially deciding that the people in X part of the state were going to be represented by a Democrat and the people in Y part of the state were going to be represented by a Republican, that the people in those respective districts